Good evening, everyone. Thank you for joining us. I'm so glad you could participate tonight in our ongoing educational webinar series. So for those who don't know me, I'm Jennifer Aubie, and I am a financial planner here in Westminster, Mass. And this call is open to anybody who got the link. Really, these are informational sessions that I hold bi-monthly to empower the community as well as clients, friends, family, with practical knowledge that will help make you smarter and help make more intentional financial decisions, as well as personal decisions about various topics such as Medicare planning, Social Security planning, financial planning, and tonight we're going to talk about estate planning. So I think it's important that you understand key concepts while you will lean into your financial professionals, such as your tax planners and your estate planners. I believe that these sessions really help you feel more confident and in control and make better intentional decisions. So you don't have to be an expert. That's what we're here for. But when you understand the why behind what you're doing, it can really help you make better decisions to reflect your values and your goals. So I appreciate you joining tonight. I want to take a moment and introduce our speaker. So I'm just going to read a bit of her bio. Tonight, we're fortunate to be joined by someone who embodies that same philosophy of empowerment, attorney Christina Vikstrom. She's the founder and principal of Vikstrom Law Group in Worcester, Mass. She focuses her practice on elder law, estate planning, and estate administration, helping seniors, individuals with disabilities, and families navigate complex legal and long-term care issues. She's a graduate of Western New England University School of Law. Her work spans from everything from creating wills and trusts to guiding families through guardianships, conservatorships, and mass health and Medicaid eligibility. What really stands out about Christina's approach is how she emphasizes personalized planning, which is also something I do in my practice, ensuring her clients are truly informed and empowered to protect their loved ones and their legacies. In addition to her practice, Christina is an accomplished speaker and educator. She presents on elder law topics to groups and organizations throughout the state, and she has a gift for making legal concepts not only understandable, but enjoyable with a good wit and sense of humor. She's also an active member of the Massachusetts Chamber of the National Academy of Elder Law Attorneys, the Worcester Bar Association, among other organizations. And when she's not working, she loves to travel, theater, and fun fact, she's also a big Star Wars fan. So join me in welcoming Christina Vikstrom as she shares her insights on estate planning. And we will open up to question and answers right at the end of the presentation. If you're going to ask a question, you'll just hit that little heart on the bottom of your screen that says react. When you push that, it will bring up a whole bunch of different emojis and things. You're welcome to heart anything she says throughout or give a thumbs up. But if you click raise hand at the end, then that will, or Christina, if you want to stop in the middle of the presentation for questions, you may do so as well. And that will allow us to open up the lines so that you can then go ahead and ask your question. So thanks for joining us and welcome, Christina.
Thank you, Jen, for that introduction. I really appreciate that. And welcome, everybody. Thank you for taking the time this evening to come and learn a little bit about estate planning. I want to make today a little less formal, so I don't want to necessarily be speaking at you the whole time, but I want to go over some important concepts and then open it up for questions to see what you may have. But I do want to caution you that on a forum like this will be shared to other people. It's probably best not to bring up your personal situation in the form of a question because number one, I'm not able to give you legal advice for your personal problems or situation without you becoming my client, but also you might not want that out for the world because this presentation will be available afterwards for anybody that would like to take a look at it. So we want to make sure that the questions are a little bit more general in nature, and always you can reach out to me at any time if you have other questions. Okay, and you can get my contact information for Jen, or I can give it to you verbally right now and then at the end. So if you need to reach me, you can go to my website at vikstromlaw.com, and that's V as in Victor, ICKSTROMLAW.com. OM as in Mary, LAW.com, and all of the contact information is right there. You can also click contact us, and you'll be put right in touch with someone at my office. Okay. So my office is very small. I'm actually the only attorney, and I have 3 full-time employees other than myself, and then we have a couple of part-time and casual employees as well. So we like to give that personalized touch to everybody and like to bring in advice regarding your situation and what makes sense for you. And it's important to remember that when you're talking to other people, to your neighbors, your hairdresser, your cousin, that their situation, even your sister, your other relatives, their situation is going to be different than yours. So what was appropriate for them may not be appropriate for you. So when we talk about estate planning, a lot of people come in to see me and they say, well, I don't have an estate. My stuff is so simple, or it's so basic. I don't have an estate. Really, if you own a home or have a retirement account or bank account, you have an estate. If you own anything, you own a vehicle, you have an estate. So don't think of estate planning for something that's out of reach for, an everyday person. It's something that everybody should consider, whether you're 18 or 100 years old. It's just that at different points in your life, you're going to need different things. And people sometimes on the opposite end of that, they'll think of an estate plan. Well, I have a will, so I'm all set. Will is a component of your estate plan, or it could be a component of your estate plan. But if you have a will, that's not all that you need. There's a little bit more that everybody needs. So why would anyone consider estate planning? There's a couple of goals that we're trying to reach here. We want to take care of our family. We want to shield anything that we're trying to pass down to our family members from paying taxes that are unnecessary, or from liability from divorce or bankruptcy. We don't want something that you're passing down to a child, half of it to end up in a divorce. So, there's certain things like that we want to put into protection, and we want to prevent taxes that don't need to be paid. We also want to simplify the estate administration process when you pass away. So we want to make that as easy as possible for the people that you've left behind, so they're not going through a very complex process. And at the same time, we want to think about how are we saving money? Are we saving money now? Are we saving money later? And so those are the real reasons why we want to take care of estate planning. The components of estate planning that protect you while you're still living are probably more important than what happens to your stuff or your assets when you pass away. And we want to make sure that we have somebody in place and a couple of alternative choices that can make medical decisions for you if you can't do that yourself, if you become sick and you become incapacitated. We want to make sure that you've also named somebody to make financial decisions for you if you can't make those yourself, if you've become incapacitated or you're very sick. And we have a power of attorney that names somebody to make financial decisions for you. And we have a healthcare proxy in Massachusetts that names somebody to make medical decisions for you. We want to make sure that you've thought about those choices very carefully, because you don't necessarily want to put the same person in charge of healthcare decisions as you do as in charge of your financial decisions, though they could be the same person. And we want to take a look at alternatives as well. That forms the base backbone of every estate plan that we do, whether someone is very young and they're a newly minted adult at 18, or they're 100 years old. They're going to need a very well thought out and drafted healthcare proxy and a very well thought out and drafted power of attorney document. We want to make sure those documents are complete and we're not missing anything. If somebody doesn't have one of those documents or doesn't have both of those documents, and they become incapacitated, they're going to need, or their family is going to need, to go to court and get a guardianship or a conservatorship for them. And that is a very time-consuming and expensive and stressful process. We want to avoid that at all costs if we can. If you have documents, but they're just not sufficient and it's missing things, say you printed something offline or you used, LegalZoom, I hate even saying the word, you're not going to get something that's very state specific or specific to your needs. And when it comes time to use that document, if something is missing and we have a provision that we're looking for, it's not there, we still have to go to court and get conservatorship. So some people get a false sense of security. Oh, I have one of these documents, but maybe it's not serving them. Maybe it's a document that was really great for a 24-year-old person just starting out in life, but it's not really wonderful for someone who's in their 70s. So you want to make sure that you're reviewing these documents, you have the appropriate things in place to avoid going to court unnecessarily. So again, that covers just basically your healthcare and your finances. It's a little bit more complex than that, but we go over all of that in a meeting in my office, if you were interested in talking more about that. Then when you get into the rest of the estate plan, there's two different directions to go. You can do a trust-based estate plan or a will-based estate plan. And a will is instructions for the court on how you want your assets divided, but it does go through probate. So a will does go to court. A lot of people think, I have a will, my estate's not going to need to go to court. That's not true. It does. That's the instructions for court. If you don't have a plan at all and you don't have a will, Massachusetts and every state, they have a default estate plan for everybody. They just give everybody the same estate plan, the same basic will. And they say, okay, this is how your assets are going to be divided. But by drafting a document, you decide how your assets are going to be divided and what happens if one of your beneficiaries that you chose passed away or they're disabled or whatever the situation would be, what happens then? So you're able to plan for contingencies. So you don't want the state ever giving you the default estate plan. You want to take care of that yourself. If you choose a trust-based plan, a trust on its simplest form is instructions on how you want your assets divided, but we cut court out. So we don't have to go to court. We cut the whole probate process out, saving a lot of money. So there's a lot of legal fees that are associated with probate. There's also newspaper publication costs, there's court fees that we have to pay directly to the court. It's very time consuming. We can avoid that with a trust, but there's a little caveat with that. Even though the trust can be very well drafted, if the client, if you don't fund your trust properly, meaning you work with someone like Jen and your banks and myself to make sure that all of your assets are connected some way to your trust. Either your trust now owns those assets or your trust becomes a beneficiary of those assets. And again, it's a little bit more complex than that. I guide you through all the specifics to your specific situation. But if you don't do that funding, it's as if you didn't even have a trust to begin with. And that's where a lot of people fail. They get their trust drafted, they lose steam, and they don't follow through with the funding. So that's really, really important step. We make it pretty easy for you. We give you a checklist. It might look a little overwhelming when you get that checklist after everything's drafted and signed up, but literally every week or every month, you could take a little section of that and say, I'm going to work with this such and such bank today. I'm going to work with Jen today, and I'm going to take care of all of these things. And you just check them off, and you just take a little piece every day and you take care of it, and it's done. If you own real estate and you've chosen a trust-based plan, then, we certainly will help put that real estate or multiple pieces of real estate into trust for you. So you don't have to worry about that. There are many different types of trusts, and people will have these different types of trusts or different provisions inside of their trust based on their specific situations. It's a little bit more than I'd like to get into today. It's a little bit more complex, but I did want to bring up one particular type of trust, which is an irrevocable Medicaid trust. That is very, very different than a trust that we would do for just basic estate planning. When you do an estate planning trust, it's a revocable trust, meaning that you can make any changes that you want at any time. You're in charge of the trust. You've created it. You're in charge of it as trustee, and you're your initial beneficiary. So you have complete control. You can make any changes that you want. You can do whatever you need to do to that trust throughout your lifetime. If you do a Medicaid trust, it's irrevocable. You are creating that trust, but you are not the trustee. You no longer own that asset, and you are not the beneficiary of that trust. So that's a pretty significant decision to make. Most clients, if they're considering such a trust, the only assets that really make sense for them to utilize in a trust like that would be life insurance and real estate. So you can still live in your real estate even though you don't have control over selling or whatnot. And your life estate proceeds, well, unless you're planning on tapping into the cash value of that, the death benefit, you're not really taking advantage of that until you pass. So those are the things that make the most sense for most clients to put into an irrevocable trust, though there are exceptions. Whenever we're talking about these documents, we want to be really careful that we think about the people that you're putting in place to make decisions for you, whether it's someone that's your power of attorney agent, someone that's making healthcare decisions for you, or somebody that is your trustee. You have to make sure that you really honestly trust this person. You can, on some documents, change who you've listed in some of those caregiving roles or those decision-making roles, but in that irrevocable trust that we talked about, there's less room for you to be able to make that change. My office, we always draft language in there that gives you the ability to make that change if necessary. But unfortunately, a lot of trusts that I review, that is a provision that's missing. So you make a decision, and if you become estranged to that family member down the line, there's nothing you can do. But we take care of that. And we mitigate that risk in my office with some special provisions. I already talked a little bit about being aware of, DIY estate plans or online documents. They're really not worth it. Yes, they're inexpensive. You do get what you pay for. And I'm on the 5th floor of a building in downtown Worcester, and I say, actually, it's not downtown. It's just a side of downtown, but in Worcester. And I always say, if you use LegalZoom, you might as well take whatever it costs, open up the window in my office, throw it out. Because I mean, that's basically what it's like, throwing the money right out the window. It's not going to be personalized to whatever state you're in. It's not going to serve you particularly. And you're going to have a false sense of security. You're almost better having no plan than you are having that plan. And that's, pretty significant. Once you have a plan in place, you want to make sure that you understand that it's not a set and forget type of matter. You want to go back to it every now and then, and you want to take a look at it. So just like you go see a doctor every once in a while for a checkup, I might recommend that you come back every 3 years, every 5 years, every year, every 2 years. It depends on your particular situation. And then it's up to you, outside of those regularly scheduled appointments for follow-ups, that if you have a major life event change, health crisis, death of a spouse or a child, you have a child that develops a disability, or you just have a birth of a child or a grandchild, it's important that during those major life event changes that you give me a call and we have a review. We want to make sure that your plan matches your current situation. You want to make sure that you don't have outdated beneficiaries associated with your accounts. Again, that we've done that trust funding. And if we have a follow-up a year after our initial plan and you haven't done your funding, you've had a whole year to do something. If you haven't done anything, well, then I can kind of light the fire a little bit and tell you we really need to get the funding done, and we can get that going. We want to make sure that you don't have old or out-of-state documents. So if you move, you're going to want to meet with an attorney in the state where you reside at that point, because not all states are the same. They have different probate codes, and they have different documents, different ways that they handle the documents. So there's no guarantee that if you have something drafted in one state that it's good in another. A lot of times it is, though. And in my office, while I'm only licensed in Massachusetts, I'm not licensed in Florida or in California or in Arizona. I do have a lot of clients that will split their time there and may become a resident there. So I build provisions into all of my documents that if you go to these main states that are really popular for retirement, Maine actually being one of them, then you are all set with a lot of the provisions that we're looking for. But if you become a permanent resident of that state, then it really is imperative that you meet with an attorney in that state. And then the other thing that is, relatively new, we want to make sure that we're not overlooking digital assets. We want to make sure, if you have cryptocurrency, that we're taking care of that. If you have, I don't know, 10,000 songs downloaded somewhere, or you have access to some information. Maybe you wrote a book or whatnot. And it's all online. It's unpublished, and it's being stored somewhere securely for you. That we talk about, how is someone going to have access? Who owns that property? Who owns that intellectual property or that financial asset? Sometimes with younger clients, we have DNA that's being stored. It could be cord blood for a child. And this would be for a younger person, because they didn't do that when I was young, but when they become an adult, they may take rights to that cord blood, that genetic material, and they may be able to use that if they get sick for stem cell therapies and whatnot. So if they pass, well, what happens to that? If they have a child, perhaps their child could be able to use that genetic material, but we have to have a way that passes that on. If you have frozen embryos or eggs or things like that, we want to make sure that we have very clear instructions that if you were in a marriage, that your spouse could continue to use that genetic material, or if you were passed, that no, you do not want that to be used. So those are some things that we'll ask in our questionnaires just to see if that applies. And again, that's mostly for our younger clients. when we talk about the components of your estate, I mentioned a little bit earlier, some people think that they don't have an estate, and they do. We want to think about real estate. We want to think about retirement accounts and investments. We want to think about all of your bank accounts and, if you have a car, a boat, any of your personal items or collectibles, those are all part of your estate. Again, I don't want to make this too overly complicated, so I want to skip a little bit into talking. I want to touch just a little bit on the other component of what I do, and that is elder law and what that is. So just want to touch on that very briefly. So elder law, there's not really a one thing that an elder law attorney does, but everyone that practices elder law should be an estate planning attorney. But everyone who is an estate planning attorney is not an elder law attorney. And that's important to keep in mind, because if you see someone who's an estate planning attorney, they may be drafting documents for you, and they may be thinking about someone at retirement age, but maybe not thinking about what happens when they get to be 80 years old, 85 years old, and what type of special things that they're going to need and provisions in their documents. So it's really important that we're not missing things in our power of attorney and our trust document or whatever other documents we have that are going to serve us as we get to those later points in life. One of the biggest things that I do as an elder law attorney is I do Medicaid planning. Medicaid planning is Medicaid is Mass Health in Massachusetts, and unfortunately, Medicaid is a changing landscape right now, and so we want to make sure that if you get to this point and you need Medicaid, that you know what planning options you have, and there are options that we can use that are before you ever need Medicaid or Mass Health in Massachusetts. And then there are options that you're already there and you can't take advantage of those advanced planning options. There are last minute planning options. And even though those probably will change as time goes on, there are options. And it's important for you to understand that the most traditional use of Mass Health for older people is going to be nursing home care. It's important for you to remember that the nursing home is never, ever going to tell you how not to pay them. They're going to tell you to spend down your money until you reach whatever the limit is, and then they'll point you to a resource to get you on Mass Health. And you don't have to do that. You can have assets and still be on Medicaid/Mass Health in Massachusetts. So that's just important to remember. Again, I'm not going to get into all the complexities of that because that would take well over an hour, but it's important to just remember that there are solutions out there. And you don't have to fall within their strict asset or income limits. There are ways to work around those. And I think that's basically everything that I wanted to cover today. I wanted to leave enough room for some Q&A. I did want to just let you know that if you wanted to ever, come into my office and have a consultation, that we just send out a questionnaire. We offer consultations virtually. We offer them in person or on the phone. Everybody has a different preference on how they'd like to do business. And then we go through a couple of steps that will then lead you to getting a summary letter of your entire plan that's in plain English. So you are not stuck with your drafts trying to understand these legal documents that probably will just put you to sleep, but you have a guide to go through those legal documents. And then once you've reviewed those and you know that those are the decisions you want to make and you have no more questions, then we just have you come in and we execute those documents. So we have you sign them. And then at that point, we put together a binder for you. We give you digital access to your documents, and everything is secured through a portal, or we can do it through the mail, the old-fashioned way, anything that you prefer, however. And we work on helping you fund your documents if you have chosen a trust, on how to fund your trust. So that's basically the process that we have in our office. So I wanted to leave plenty of time for questions. Does anybody have any questions right now that want to raise their hand or?
Yeah, again, don't go too deep and personal. This will go on YouTube, but if there's reasons you're like, I just want to know about XYZ, and that's why I'm getting on this call today. I mean, feel free to raise your hand, and want to make sure you walk away with what you came for.
Mm-hmm.
All right. Mike, are you able to unmute? Yep, you're unmuted, Mike. Go ahead.
I was wondering if you could just discuss a little bit about long-term care options, um, and what you think is out there today for, let's say, older people.
When you say long-term care, do you mean like care, like actual care options, like facilities and in-home care and programs like that, or do you mean planning on
Yes,
pay
yes,
for?
specifically long-term care insurance.
Okay.
Insurance.
Um, so long-term care insurance is a great product. Jen, you can speak a little bit more to that. That's not something that as an attorney we will recommend that someone look into that product, but I don't prepare those. I'm not an insurance agent.
Maybe
But
you could touch on how it complements your planning, and then I can touch on those products.
yes. I will give you a good world example right now, real life example. I have a client right now. I'm actually her guardian. Her family is estranged from her, but they wanted to make sure that she was very well taken care of, and she did, almost everything by the books, when she was well enough to take care of her finances. And she had a very, very robust, she has a very robust long-term care policy. We're able to get her very, very good care at a rest home. A rest home is something that's not quite the level of care of his nursing home, but it's one step up from assisted living. And that care is going to be almost entirely paid for with her long-term care policy. And the shortfall from her policy and what it costs per month for that particular facility is more than covered by her monthly income. So her assets are actually not decreasing. And she had that policy for over 4 years. She's going to have it for over 4 years of payout. And this was a wonderful product. Not everyone is as lucky enough to have something like that. I know the products have changed over time, but she did a one-time, I believe she did a one-time purchase of that product. And when you're receiving the benefit, you're not paying the premium anyways. So whether you're doing a one-time payment or it's a quarterly or annual payment, the premiums stop. And it gives you the flexibility, that insurance. We were able to use it for home care for her when she was still at home. We were able to use it for assisted living when she went into assisted living. And now we're able to use it for rest home care. If she requires more care than she can, and so she can't stay at the rest home anymore and needs nursing home care, then we'll have that as well. And that will more than cover her nursing home care. I will tell you, on average right now in Massachusetts, the average cost of nursing home care is about $17,000 a month. And I think that is a shocking number that a lot of people aren't prepared to hear. So if you don't have a plan, or you can't get on Mass Health or Medicaid if you're in another state, it can be shocking, and that you can run down your assets pretty quickly. But there are options out there that you don't have to spend down all your assets, but the facility is never going to tell you how to not pay them. They're going to prefer that you pay them privately, because they're going to get about half or less than half from the state of what you would pay privately. So they're not interested in telling you how not to pay them.
And you have more
Um,
options open.
Right, and you have more options. I mean, some policies you can even use to making your bathrooms handicap accessible, putting ramps in your office. I mean, some of them will even cover like incontinence supplies and things like that. It just depends on the particular policy. I'll let Jen speak more to some of the combo policies that are available now, where you can either have a long-term care insurance policy with a life insurance rider, or you can have life insurance with a long-term care insurance rider. And at the very end of the day, oversimplifying, of course, here, because we're just talking in generalities, there's very few insurance policies out there that you can pay for that will pay out as life insurance if you don't use what you paid in. So they can be wonderful products for people that they understand that, okay, if I buy into this and I don't use it, or I only use a little bit of it, at least what I put into it plus some interest is going to go to my family, and that's going to be paid out. So that is a great benefit to some of these policies that are available today that are different from what was available in the past.
Yeah, so in the past, we saw a lot of traditional long-term care. You pay in annually and you pay for your entire life until you go on claim. So you may pay for this policy for 50, 60 years, which is a really, really long time. And if you did not have a long-term care event, they often didn't pay out anything. So the policies that we're offering today are, as Christina mentioned, they're hybrid policies. So you might have a life insurance policy. So it's built on a life insurance chassis with a long-term care on top of it. We have some that are annuities that have a long-term care on top of it, et cetera, but they're hybrid policies, and you can pay in one lump sum and you can pay over 10 years. There are all kinds of options. Now, no long-term care is inexpensive, but it does leverage a much larger benefit. And the younger you buy it, the more leverage you have for that long-term care. Typically with these policies, the qualification is that you cannot perform 2 out of the 6 activities of daily living for all of them across the board. This is eating, bathing, toileting, dressing, continence. Eating, bathing, toileting, dressing, continence, and transferring. So that's 6. So 2 out of those 6 you cannot do as declared by your doctor. So not by me, not by the insurance company, by your personal doctor. When they say you can't do 2 out of the 6 of those, you can go on claim. They do generally pay for at-home care. They do pay for some of them pay for a family caring for you, a family member. Some only a professional. It kind of depends on the policy, the company doing the writing of the policy. But they also will, some pay out just right as soon as you go on claim, they send you a certain amount a month, and others are a reimbursement policy where you outlay the funds and then you submit receipts and then you're reimbursed. So they're all different types. So again, speaking in these generalities, if that's something you're interested in, then we can look at the different options out there and what might suit your situation the best. And of course, you do have to go through underwriting. So if you have any pre-existing conditions that may disqualify you from long-term care policies as well.
Thank you.
Mm-hmm.
And I find a lot of my clients as well, by the time they're ready to listen to that conversation about long-term care insurance, or they're open to it, sometimes they've missed the boat as far as underwriting is concerned. A 75-year-old saying I'm ready, it might not be the best time, whereas if they were much younger, it would have been the right time to at least consider it and take a look at options. And, that's unfortunately what I see a lot in my office. Or, the other day I had an 83-year-old gentleman who had a whole host of health issues and he wanted long-term care insurance, and it was not a good match at that point in his life.
Yeah.
The other benefit to long-term care insurance is if you spend your benefit or you don't spend your benefit, doesn't matter. But if you have $1 left on your policy, so I always tell people, don't spend it all the way down. Have a little bit of money left on your policy. It could be $1, $100, $1,000, whatever it is. And you need to go into long-term care, into a nursing home, and you apply for Mass Health. Mass Health will not count your primary residence as an asset. So it shelters your primary residence. So that is a big benefit that a lot of people don't realize, or if they're not working with an elder law attorney, they have this insurance, they spend all their insurance, and then they go to apply for Mass Health. And unfortunately, they came to the attorney a little bit late, and we find out, well, they don't have anything left on their policy. If they left just $1 on their policy, there'd be a shield basically around their house, and they could pass that on to whoever their beneficiaries are without Mass Health wanting them to sell that home to contribute to their care. So that is a major benefit, and it's very important to keep that in mind.
Thank you.
Mm-hmm. All right, I think we have another question. Dave, go ahead and unmute. Lower left corner, I think, is the mute button. Let's see. Let's see if I can unmute you. No. There you go. You got it.
Okay. I was informed by an attorney not so many years ago that as I was entering retirement and the likelihood that my assets, including the house, would not exceed $2 million, that I had absolutely no need for a trust, that it wouldn't shelter me anyway, and that when the time came, I would be permitted to live in my house, even if my wife went into the nursing home and took half of my monetary assets with her on the way.
Okay.
So is there any veracity to that? And
It's a very,
was it bad advice? I'm glad I didn't say the attorney's name, but was it bad advice?
It's a very loaded question. I think the first part, when you're bringing up 2 million, you're talking about tax planning. That's one of the reasons why we'd have a trust, is to do some tax planning. And that would really only apply if you had a spouse. So you did mention at the end that you had a spouse. So if somebody does have $2 million in Massachusetts right now or more in assets, then we can do some tax planning in a trust. And basically, without getting too overly complicated, when the first spouse passes, we kind of divide the trust into two different buckets of assets. And we're using the first spouse's $2 million exemption. And then when the second spouse passes, we can use up to $2 million again. And we can avoid some of those estate taxes. Yes, if you have less than 2 million, you maybe don't have to worry about that. I think the likelihood of Massachusetts bringing their level down is slim. I'm not going to say it could never happen. They just went from 1 million to 2 million very recently, about a year and a half ago. The federal limit is way up there now. It's almost 15 million. So we don't have to worry about those federal taxes right now, but we don't know what's going to happen federally. Even if they lower it in the future, that limit, the likelihood of it coming all the way down to, $2 million is very, very slim. But, they could, from the very high number they have now, could come down to 10 or 8 or 7, whatever it is. But so we don't necessarily, in this situation, in this example, have to worry about taxes, but trusts do a lot more than just tax planning. So what trusts do is they avoid probate. Probate costs right now in Massachusetts for an average, just basic estate with maybe a piece of real estate, a car, a couple of, retirement accounts that maybe were set up appropriately, maybe they weren't, some bank accounts. We're talking $7,000 to $10,000 right now in 2025. That's legal fees, court fees, newspaper publication costs, postage, things like that. That's about the average cost of going through probate. If you don't have to go through probate, you cut out all those costs, and those costs just go up as time goes on. Also, with the trust, you're able to shelter beneficiaries. So if you have kids and you leave something, say to your son, and then your son gets divorced, half of what you left your son doesn't walk away in the divorce. If your son, just using this as an example, if your son, filed for bankruptcy, all the funds that he, and then you die and he's receiving an inheritance, all those funds aren't tied up in the bankruptcy. If a child had some other kind of liability, they hadn't paid some bills, they're not able to attach the inheritance. If they were in a terrible car accident, God forbid they killed somebody or they severely injured somebody, there's a personal injury lawsuit against them personally, their inheritance isn't going to necessarily be taken in that lawsuit. The trust shelters that. If you have a child that becomes disabled and then they're on public benefits, if they receive a distribution from your estate, that could remove them from their public benefits. Then they'd have to spend that money down and then reapply. That could be very burdensome. We can avoid that last example sometimes by going to court and doing some post-death planning. But then again, we're tied up in court. It's thousands and thousands of dollars. If somebody's setting up an estate plan and they have young grandchildren or grandchildren that are being born, we don't know if they're going to have special needs issues that we need to have special needs trusts for. We can build some default language in when we don't know about those grandchildren yet, so we can cover them for specific things. Once we know if someone has a special need or whatnot, we can go in and we can tune that up and make it a little bit more specific to their specific situation, but we at least have something in there that protects for all those unknowns. Also, we can get very, very specific about what happens if you leave some things to your children and one of your children passes. Well, do you want what they would have received to go to your other children, or do you want it to go to your grandchildren? Some combo of that? Do you want it to go somewhere else? Do you want to include, charities? Do you want to include, other beneficiaries that aren't family members? We can get very, very specific with what you're looking to do, where as a will-based plan, you're limited on what you can do. You can plan for some contingencies, but it's very, very limited in scope. And we're not protecting for things like divorce, bankruptcy, things like that.
Roger that. Looping back on the original question, however, one of the things that it leaves me with is as a sort of a nightmare is that my spouse goes into a institution. Massachusetts comes and raids basically half or more of my cash and leaves me with an amount of money that's really not sufficient to live on, is that a likelihood? Is that the reason I should head for a trust as fast as I can?
Depends on what you have for assets. Different types of trust planning might be able to shelter some assets for you. You might be using some of that type of planning with the irrevocable trust that I mentioned before. You might be just making sure that you have really well drafted powers of attorney in place so you
Well-
could take advantage of last minute planning when and if that happened. The limit right now for a married couple is just over $159,000 plus one car plus your home. And the kicker is that they don't tell you this. If you have an attorney, obviously they'll tell you this. You got to make sure if your spouse is in the nursing home that you take their name off of the deed, because there's no penalty for transfers between spouse. So we transfer the deed, and then Mass Health doesn't have the ability to put a lien on your home. Otherwise, they put a lien on your home, you're stuck. You literally can't sell that home as long as your spouse is living or in a facility. If you wanted to move or downsize, you're not able to do that. Or you are, but if you do, you have to pay back Mass Health for what they paid on the spouse's care. So there's a lot of moving pieces to it. It's very, very, very specific to your specific situation. They're not going to come take half your assets, but they could take a lot more than that. It depends on what you have. $159,000, your primary residence, one car, and there's little things like they'll let you have prepaid funerals. You can have little burial accounts that have $1,500 in them each. You can have very small life insurance policies that don't count, but other than that, they're going to look at all of your assets. So everybody's situation on what they want to do for planning and what they're comfortable with doing, because again, if we're using any irrevocable trust, you're giving up control. So if you're naming a child or someone else to be in charge of that, you're trusting that they're going to do what you'd like them to do later. You have no legal recourse or very limited legal recourse if you don't agree with what they're doing. You can say, hey, I'd like to do this. They could say, no, I don't want to do that. You're kind of stuck. So there's trade-offs from some of the protections that you do in advance versus some of the protections that you can do last minute. Again, without getting very complex with the discussion or getting into, diving into really your personal situation, in a spousal Mass Health type of situation, if you're applying for benefits in Massachusetts, we don't have to spend down all that money that's over the $159,000. We can actually put in place a Medicaid or a Mass Health annuity. And what that does, it's almost like a little magic trick, but it's legal money laundering, I call it. It's not really money laundering. You're able to do it under the Massachusetts code and Medicaid code, but they're saying, okay, you have this here. This is an asset that you can't have. This disqualifies you. I'm sorry, you can't see it because I blurred my background. I'm holding up a pen. I'll just hold up my hand. So here's an asset that disqualifies you, but we're going to put it in the cloud. We're going to put it in this annuity. And this annuity is going to do the magic trick to it. It's going to pay back that spouse at home, and now it's an asset. Mass Health no longer cares what the spouse at home has for an asset. So as that asset comes back to the spouse, as the income comes back to a spouse, now they don't care what you have for assets anymore. You can do whatever you want with those assets and you can reinvest them and whatnot, but it has to flow through the annuity. And there's lots of complexities there, depending on what your needs are, how fast we want the money to come back or how slow we want the money to come back. But you don't need to spend the money down. Yeah. But the caveat with the annuities is that if you have, IRAs or 401ks, in order to take advantage of those annuities, you're cashing those out. So you're paying the income taxes on those. Right. So that can be a pretty significant hit for some people.
Well, by the way, that last statement with the magic and back down the other side, that at least gives me some comfort with where I stand right now. But
I much overly simplified that process just for illustration purposes.
I think I need to delve into this a little more deeply.
Yes. And I will just give you one little caveat too. Sometimes we forum shop. We shop for different states. Rhode Island right now doesn't have a law on the books that you have to cash out those tax accounts like the 401ks and the IRAs. You can still leave them there. You don't have to cash them out. So sometimes if people have a significant amount of assets in that, we'll look to Rhode Island and say, does it make sense for us to utilize a Rhode Island institution? At that point, if you're my client, I can't help you anymore. I can set you up with a colleague down in Rhode Island. But we have done that before. We've shopped different areas. A lot of people from New York come to Massachusetts because Massachusetts is a little bit more friendly than New York is. And then again, we do have some people on, the southern, at least the southern part of the Commonwealth, that will end up going to Rhode Island because they feel that that's the best bet for them. It's very, very personalized.
Cool. Thank you.
Any other questions before we wrap? Thank you for those questions. Give it another second. All right, well, as I'm talking, if you are digging around for your raise hand button, feel free to raise it. I'll pause as I kind of wrap this up. But if you want to discuss these concepts according to your own personal situation, please feel free to reach out to Christina or I, because a lot of this is so nuanced. And I think, I've worked with the Medicaid annuities. I've written a couple of the contracts for them, and yeah, that was definitely I like that explanation. But yeah, there's so many different vehicles to accomplish what you want, and it's really that trade-off that you have to weigh that I find that I'm talking to clients about a lot. Like, do you want control of your assets? Are you okay giving that up? And and then maybe you end up using some later planning techniques. But I appreciate you, Christina, for joining us and for the work you do for people to really help them understand these concepts and put them into place to protect their families and their interests. And thank you for everyone who joined tonight. I appreciate you spending your early part of your evening with us, and keep an eye out. We're doing these every other month. We started every month, but I think people get busy. So we're doing and we'll put it in the newsletter, and we'll send out the separate email so you can sign up. Feel free to share on social media, invite your friends, family, if there's a topic you think people are interested in. And I hope you have a great evening.
Thank you, Jen. Thank you, everybody.